It is one thing to write a will, but quite another to write a valid one. Hi family, welcome back to my little corner of the internet and welcome into our home. My name is Bupe. I am passionate about God, charity and the law. And if you like that kind of content, you're at the right place. Last week we looked at a will, and big shout out to Hope. Thank you for your comment in requesting to make a video about how to make a will, and so this is that video. First things first, disclaimer. Okay, this is not a video giving you a guide on what the content of your will should be. I am basically sharing with you what the law requires to be in your will, or at least the structure of your will. To write a will, please do get professional help and you will see why. We saw last week that if a person dies without leaving a will, they are said to have died intestate, and the law that applies to them is the Intestate Succession Act. But if someone dies leaving a will, the law that applies to them is the Wills and Administration of Testate Act, Chapter 60 of the laws of Zambia. Okay, now that we have that foundational business out of the way, let's just move on. Next basic is what really is a will. So a will is basically a document where a person leaves what they want to happen to their estate once they have died. What is an estate? Everything that belongs to you, everything that you own. So basically, if you kick the bucket, how do you want your property to be distributed or to be dealt with? That is basically what a will is. Next, who can make a will? Only two requirements. You should not be a minor below the age of 18 and you should be of sound mind. So anyone outside of these two restrictions can make a will. Now remember, in the beginning I had said that it is one thing to make a will, but quite another to make a valid one. I will read to you now what makes a will valid verbatim from the Wills Act, so that we understand what makes a will valid. Okay, so this is what the law says. We are in section 6. I dreaded this section in school. Oh gosh. It reads, a will shall be valid if it is in writing and is signed at the foot or end by the testator or by some other person in the testator's presence by his direction, and the signature referred to in paragraph A, which is what I just read, is made or acknowledged by the testator in the presence of two witnesses present at the same time who have also signed at the foot or end of the will. Any person who is not blind and is of sound mind may be a witness to a will. So, as you have seen, we could just summarize it in 3 points what makes a will valid. So we're saying, 1, it has to be in writing. It has to be signed at the foot or at the end by the testator. So basically the testator is the person who is writing the will, and the signature must be made or acknowledged by the testator in the presence of two witnesses present at the same time. So basically those are the 3. You have a document where you put down in your document, this is the property I have. I want Bupe to have my airline. I would like my daughter to have the 50 million in my account. I would like my parents to have my 50-acre land. Once that is written down, then the will is signed, and this signing should be witnessed by two witnesses present at the same time. Okay, so wills. So Sorry I made it look easy in the last video. Otherwise, there's just a bit of technicality dealing with this. There's just a bit of technicality. Then we move on to the witnesses. Since you are giving Wupe your airline, she cannot sign as a witness to your will. The consequence of Wupe signing as a witness to your will when she is the beneficiary is that she runs the risk of losing that gift you have left to her. So if you're writing a will, you would rather that your wife, your children, and anyone you're gifting anything in your will is not a witness to that will. It's just what the law says. Don't shoot the messenger, just delivering the message. So, two people who cannot witness a will is blind, they can't be a witness. If someone is of unsound mind, they cannot be a witness. Okay? A beneficiary who intentionally causes the death of the testator, the person who made the will, cannot be a beneficiary to the will. You do yourself a number, you cannot benefit from the will. The beauty of writing a will, like I said from the last video, and if you did not have a look, remember to like, share, and subscribe, but go and check out the last videos on the 5 reasons why you should leave a will, because it gives you more leverage what you want to do with your estate. Unlike when you die intestate, you have those 20% to your spouse, 20% to your kids, and whatnot to your mother and your father. And then you'll find that you have small children who may be deprived because you didn't make proper provisions for them in a will. Remember how when I began the video, I had talked about it is important for you to get professional help, and this is not a guide on how to write what you're writing in a will? Yeah, these are some of the reasons. So once you have died, your executor, assuming that you had appointed an executor in your will require to get a grant of probate for them to wind up your estate. But in order to do this, the will still needs to be proved before the court, and the court will look at section 6 to see if your will met the qualifications of section 6. Now, on the face of it, it might sound easy and straightforward, but the truth is there are questions that can arise. Does the document qualify as a will? Was it written on a document? And a document is not always a paper. Okay? Another question that can arise is, how was the will signed? Were the two witnesses present at the same time? Further, what did the witnesses actually witness? Did they witness the testator, or you in this case, write down the contents of your will, or was it the signature they were witnessing? So it can be a bit of a tricky situation. So yes, I know people say that lawyers are expensive, but look into how you can find professional help to write you this will, because in the long term it's a worthwhile investment, and it's just good for the courts of law not to dismiss your wills as invalid on the basis of a technicality. So you want your witnessing to be done right, your writing to be done right. I mean, even a small thing like what is the foot of the will, or what is the end of the will? Can the end be at the top of the page, or is it always at the bottom of the page? Again, it comes back to on what document was this will written. Should it be a plain? Yeah, so there's so many. There can be sometimes some small and big technicalities that arise from drafting your will. So if you can, please get professional help to write this will, or if you've written one, at least maybe it could cost less if you just went to consult if it has been done right. But by all means, get a professional help. Thank you so much for joining me. So that's that about writing wills. You want it to be done by a person who is of sound mind and who is older than 18. You don't want it to be by a minor, and it should be witnessed by 2 people present at the same time, and it should be signed or acknowledged at the foot or end of the will. But by all means, get professional help. Until the next one, this has been Wupe. I have to love and leave you. Bye.